This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about piecemeal litigation and why it is inefficient and risks inconsistent judgments, and also why in an insurance dispute interrelated acts constitute a single claim, which resulted in the multiple and different lawsuits seeking appellate review of part but not all of a case. In Yonah Rothman versus Complete Packaging and Shipping Supplies, Inc., and Mitchell Mankosa, Complete Packaging and Shipping Supplies versus Arch Insurance Company, the United States District Court for the Eastern District of New York on August 4, 2025, dealt with the attempt to obtain a piecemeal or partial appellate judgment. Complete and Arch litigated the disputes about coverage in relation to the Rothman employment discrimination actions. Yonah Rothman had filed a lawsuit against Complete and Mitchell Mankosa alleging employment discrimination, underpayment, and wrongful termination. Rothman claimed he was retaliated against for participating in a separate lawsuit brought by another employee. Complete sought defense and indemnification from Arch based on their insurance policy. That policy covers conduct between December 5, 2021 and December 5, 2022, and includes an interrelated claims provision. The court dismissed Complete's third-party complaint seeking defense and indemnity from Arch. The dismissal was based on the finding that the Rothman actions arose from the same interrelated acts, constituting a single claim made in 2020, which was outside the policy's coverage period. Complete filed a motion for entry of a partial judgment under Rule 54B to appeal the dismissal order. The court highlighted concerns about the immediate appeal of indemnity issues which are related to liability and may require the appellate court to address factual issues still being litigated. Complete filed a third-party complaint against Arch seeking defense and indemnification in the Rothman action based on an insurance policy, and the policy that had a limited coverage for conduct between December 5, 2021 and 2022. The policy's interrelated claims provision provided that all claims arising from the same facts were considered a single claim and deemed to have been brought on the date of the earlier claim, which is before the Arch policy came into effect. The United States District Court noted that the employment discrimination actions arose from the same interrelated acts, the alleged retaliation by Complete against Rothman for his assistance with another lawsuit against Complete. Judge Merchant held that the two actions constituted a single claim made in 2020 outside of the policy's coverage, and Judge Merchant therefore granted Arch's motion to dismiss. The district court concluded that the long-standing policy against piecemeal appeals required that the court's power to enter such a final judgment before the entire case is concluded. The USDC noted that permitting an aggrieved party to take an immediate appeal must be exercised sparingly. Complete offers no alleged hardship or injustice for the court to consider. Complete seeks judgment on both parts of the Arch dismissal, that is, a resolution of both defense and indemnity obligations under the contract. The district court certified as final judgments its orders holding that the insurer is liable to provide a defense and allocating defense costs amongst the insurers. Final judgment was not entered with respect to the insurer's duty to indemnify, however. Although indemnity and liability issues are in some sense separate and distinct, they are nevertheless related. Indeed, by a very nature, indemnity is collateral to and dependent upon a finding of liability. But even as to defense obligations, there's no blanket requirement that such issues be certified for partial appeal. Rule 54B judgment and appeal imposes a more demanding standard than the party's own assessment that it would be efficient to allow these appeals. To that end, a defense claim, even against a third-party insurer, must be extricable and separate from the other claims being litigated. Were the court to certify the dismissal for appeal, the Second Circuit could be forced to make an insurance coverage issue that would be undermined or superseded by subsequent ruling in the underlying litigation. Piecemeal litigation is not only inefficient, but it raises the risk of inconsistent judgments in coverage litigation that is appealed while underlying merits are resolved. So the motion for entry of a partial judgment under Rule 54B was denied. In my opinion, insurance coverage disputes are seldom easy. In this case, the court found a duty to defend one part of the litigation seeking defense from the insurer, but found that both cases were based on a single cause that occurred before the arch policy became effective. Seeking an appeal on the issue of duty to defend or the duty to indemnify before a decision was made on one issue sought to piecemeal the appeals, stretching the litigation beyond efficiency, which was properly refused. This video is adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll be given notice of every blog posting, usually 5 or 6 a week, and you'll also have access to the more than 5,150 blog posts. You can also subscribe to these videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com and subscribe to the videos. They're free. Please tell your friends and colleagues about these blogs and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publications. Thank you for your attention.